This brings us to the end of our consideration of criminal summons. It also means the beginning of our treatment of public summons. Who has authority to publish, or who publishes a public summons? Well, recall that public summons only applies under the ACJA and the CPC. In both jurisdictions, it is published by a judge of the High Court in writing. See Section 42, subsection 2 of the ACJA and Section 67, subsection 1 of the CPC. When can public summons be employed? Well, basically on two grounds. One, published on the grounds of abscondment or concealment of the person for whom a warrant of arrest has been issued. Second, published once a judge has a reason to believe that the above is true, irrespective of whether or not evidence has been taken. What does Section 41 of the ACJA have to say about this? If a court comes to the conclusion, whether after obtaining evidence or not, that a suspect against whom a warrant of arrest has been issued, 1, by itself, 2, by any court, 3, a justice of the peace has either absconded or is concealing himself so that the warrant of arrest cannot be executed, the court may publish a public summons in writing requiring that person to appear at a specific place and a specific time, not less than 30 days from the date of publishing the public summons. And what does Section 67, subsection 1 of the CPC have to say? If a judge of the High Court has reason to believe, whether after obtaining evidence or not, that a person against whom a warrant of arrest has been issued by himself or by any court or justice of the peace has either absconded or is concealing himself so that such warrant cannot be executed, such judge may publish a public summons in writing requiring that person to appear at a specified place and a specific time, not less than 30 days from the date of publishing the public summons. Please note that while the ACJA says court, the CPC says a judge of the High Court. And while the ACJA says suspect, the CPC says a person. So what is the lifespan of a public summons? It remains in force until executed or cancelled by the judge or magistrate. Death, retirement, removal from office, promotion, loss of jurisdiction of the issuing authority are all incapable of invalidating a summons. Recall that only the ACJA and the CPC recognize public summons. So the only provisions we can dwell or fall upon are Section 139 of the ACJA and Section 383 of the CPC. So what are the contents of a public summons? They include: it must be dated, it must be signed by the issuing authority, it must contain a brief account of the alleged offenses, it should contain the name of the alleged offender, or it should succinctly describe the alleged offender. It should contain a directive to a police officer or to all police officers to execute the arrest. It must be written and it should be in duplicate copy. Recall that a public summons is the publication of a warrant of arrest. Therefore, it follows then that the contents of a public summons must at a minimum match the contents of a warrant of arrest. So what does the statute have to say about this? Section 36 subsection 1 of the ACJA uses the following expressions: bear the date of the day of issue. See section 36 subsection 1A and 85. Contain all necessary particulars. See section 36 subsection 1B. Be signed by the judge or magistrate by whom it is issued. Section 36 subsection 1C. State concisely the offense or matter for which it is issued. Section 36 subsection 2. Shall name or otherwise describe the suspect to be arrested. Section 36 subsection 2. Order the police officer or officers to whom it is directed to arrest the suspect and bring him before the court to answer the complaint or statement, or to testify, or to be dealt with according to the circumstances of the case, and to be further dealt with according to the law. Section 36 subsection 2. Section 121 mandates the production of a public summons in duplicate. Let's now turn our attention to the CPC. Section 56 of the CPC uses the following expression: be in writing, signed or sealed. Section 47 subsection 2 of the CPC mandates the production of a public summons in duplicate. That brings us to the end of our consideration of the contents of a public summons. Procurement of a public summons. It is issued by a judge upon confirming abscondment or concealment of a person for whom a warrant of arrest has been issued. Once it is procured, it entitles a private individual to arrest without a warrant. See sections 41 and 42 of the ACJA and section 67 and 68 of the CPC. The ACJL and the CPA are silent. Execution or publishing of a public summons. How is it supposed to be done? How it's supposed to be done depends on the jurisdiction. Let's take the ACJA first. Section 42 subsection 1A to C is the responsive section for the ACJA. According to section 42 subsection 1A, in a widely circulated newspaper. According to section 42 subsection 1B, pasting in some conspicuous part of the house or premises, or pasting in some conspicuous part of the town or village. He is ordinarily resident. Section 42 subsection 1C, pasting in some prominent part of the High Court or Magistrate Courts building. ACJL and CPA are silent. So let's move on to the CPC. Section 67 subsection 2A, public reading in a conspicuous place in the town or village he ordinarily resides. Section 72 subsection 2B, affixed to the house or homestead or conspicuous place in the village. Section 67 subsection 2C, pasting to some prominent part of the High Court building. It all depends on the jurisdiction. Let's take the ACJA first. Section 42 subsection 3 of the ACJA tells us that all that is required is a statement in writing from the judge of the High Court or a statement in writing from the magistrate to the effect that the public summons was duly published on a specified day. That in the eyes of the court is conclusive evidence that 1. It was published, 2. The requirements of the Act with respect to service of, execution of, or publication of the public summons have been complied with. The ACJL is silent and the CPA is silent, but the CPC is not silent. And according to the CPC in section 67 subsection 3, all that is required is a statement in writing from the judge of the High Court to the effect that the public summons was duly published on a specified day. That, in the eyes of the court, is conclusive evidence that 1. It was published, and 2. The requirements of the law with respect to service of, execution of, or publication of the public summons have been complied with. So what are the consequences of disobedience to a public summons? Let's take the ACJA first. Section 80 of the ACJA tells us that a judge or magistrate can, following taking the action or actions specified in section 41, or on an application made in that regard, post summons or warrant issue that has been disobeyed, order the attachment of any property, movable or immovable, or both, belonging to a suspect, the subject of the public summons or warrant disobeyed. Section 81 subsection 1 tells us that a judge or magistrate is empowered to authorize a named public officer to attach any property belonging to the suspect absconding or concealing himself from the execution of a warrant of arrest, and also fails to respond to the public summons if such property is within his jurisdiction by seizure or utilizing any other manner of attachment, such as by way of civil process. Section 81 subsection 2 tells us that failure of the suspect to appear within the time frame specified by the public summons bestows on the court the power to dispose of his property under attachment. Section 81 subsection 3 tells us that from the date of the attachment up until 3 months later, the judge or magistrate has no right to dispose of his property under attachment via selling, unless 1. It is of such a nature that failure to dispose of it will lead to its deterioration and loss of value. 2. The judge or magistrate is of the considered opinion that such sale would be beneficial to its owner. In both scenarios, the judge or magistrate is free to exercise the power of sale. Section 82 subsection 1 tells us that if within 1 year from the date of the attachment, such a suspect whose property is or has been at the disposal of the court as per section 80 of the ACJA makes an appearance either voluntarily or involuntarily and proves to the satisfaction of the court that his was not a case of 1. Abscondment or concealment for the purpose of avoiding execution of the warrant. 2. And that he had no notice of the public summons or warrant and so couldn't possibly attend, then, if the property wasn't sold, it shall be returned to him. And if the property was sold, then the net proceeds less cost of processing the attachment shall be transferred to him. Section 82 subsection 2 of the ACJA tells us that if after 1 year from the date of attachment, such a suspect whose property is or has been at the disposal of the court as per section 80 of the ACJA fails to make a voluntary appearance, then the property or the net proceeds of its sale shall be forfeited to the federal government or state government, whichever is more appropriate in the circumstances. We are done with the ACJA. The ACJL is silent and the CPA is silent. Let's move on to the CPC. Section 68 subsection 1 tells us that a judge of the High Court may, following taking the action or actions specified in section 67 of the CPC, order the attachment of any property, movable or immovable or both, belonging to a person, the subject of a public summons. Section 68 subsection 2 tells us that the judge is empowered to authorize a named public servant to attach any property belonging to the person who happens to be the subject of a public summons, if such property is within his jurisdiction by seizure or utilizing any other manner of attachment, such as by way of civil process. Section 68 subsection 3 tells us that from the date of the attachment up until 3 months later, the judge has no right to dispose of his property under attachment via selling, unless 1. It is of such a nature that failure to dispose of it will lead to its deterioration and loss of value, and 2. The judge is of the considered opinion that such a sale would be beneficial to its owner. In both scenarios, the judge or magistrate is free to exercise the power of sale. Section 69 of the CPC tells us that if within 1 year from the date of the attachment, such a suspect whose property is or has been at the disposal of the court as per section 68 of the CPC makes an appearance either voluntarily or involuntarily and proves to the satisfaction of the court that his was not a case of 1. Abscondment or concealment for the purpose of avoiding execution of the warrant, 2. And he had no notice of the public summons or warrant and so couldn't possibly attend, then if the property wasn't sold, it shall be returned to him. And if the property was sold, then the net proceeds less costs of processing the attachment shall be processing the sale of the attachment shall be transferred to him. This is a take-home assignment. It is a possible basis for a fact pattern or a multiple choice exam question. Please take the time to review the appropriate sections of this video and attempt to answer. And please feel free to share your answers in the comment section below. Thank you. This is a take-home assignment. It is a possible basis for a fact pattern or a multiple choice exam question. Please take the time to review the appropriate sections of this video and attempt to answer. And please feel free to share your answers in the comment section below. Thank you. This is a take-home assignment. It is a possible basis for a fact pattern or a multiple choice exam question. Please take the time to review the appropriate sections of this video and attempt to answer. And please feel free to share your answers in the comment section below. Thank you. This is a take-home assignment. It is a possible basis for a fact pattern or a multiple choice exam question. Please take the time to review the appropriate sections of this video and attempt to answer. And please feel free to share your answers in the comment section below. Thank you. What happens if someone fails to appear in court? Let's use Mr. Government Tompolo Ekpomopolo as an example. There was a case between the federal government of Nigeria and him, with the EFCC as the prosecutor. The EFCC is of the opinion that it has questions to answer in connection to a multi-billion naira fraud involving land contracts for the construction of a Nigerian Maritime University, NMU. Thus, the EFCC invited him for questioning. Mr. Tompolo is of the view that the government has an axe to grind against him, and so failed to honor a December 10, 2015 invitation for questioning at the EFCC. The EFCC, in the exercise of the powers conferred on it, then proceeded to freeze his personal bank accounts and the bank accounts of companies connected to him. The reason given for that action is that those bank accounts were channels through which some 13 billion naira of the Nigerian Maritime Administration and Safety Agency (NIMASA) were sent to Mr. Tompolo for the purpose of constructing the NMU. The court, a federal high court in Abuja, gave an order for substituted service on Tompolo for January 12, 2016, and also issued a bench warrant on January 14, 2016, and ordered all the security agencies to produce him by February 19, 2016. When that failed, it asked for him to be produced on February 25, 2016. And when that again failed, that it should be produced by March 22, 2016. And that's why I stopped following the case. In the meantime, the EFCC applied, relying on Section 80 and 81 of the ACJA, for the attachment of his property for his failure to attend court sessions. And if you follow our discussion of the consequences of failing to respond to a public summons, in 3 months, the court can order such property to be sold. And if the person does not appear after a whole year, then the property can be forfeited to the federal or state government, depending on which agency, which of them was fighting the case or prosecuting the case. Now, this is a highly summarized version of events. To get the full story, please visit the following links on the next slide. The links showing on the slide are links for more details on Tompolo's case with the federal government. It explains the power of the court to issue public summons, as well as the power of the court to issue a warrant of arrest, as well as the powers of the court to confiscate property of a suspect who fails to respond positively to a warrant of arrest or summons by being present in court. Law is procedural, and law has to do a lot with forms and precedents. And public summons is no different. On the current screen, you can see a form, warrant for arrest of defendant who has disobeyed summons, for the ACJA jurisdiction. Here is another form for the ACJA jurisdiction, warrant for arrests of defendants in first instance. Which of these forms do you think that the Federal High Court used in Tompolo's case? If it happened in Lagos, then the applicable law would be the ACJL. Here is a form known as the warrant for arrest of defendant who has disobeyed summons, applicable for the territory of Lagos. Here is another form for the ACJL jurisdiction, warrant for arrest of a witness, although we will take this more in greater detail in the next video dealing with arrests, the power of arrests or the power to arrests. Here is another ACJL form warrant for arrest of witness in the first instance. Here is a similar form from the CPA jurisdiction, warrant for apprehension of defendant who has disobeyed summons. Here is another CPA jurisdiction form, warrant for apprehension of defendant in first instance. Yet another CPA form, warrant for apprehension of a witness. Several sources were consulted in producing this lecture, such as the Punch newspaper article on the Ofa robbery and the summons against Saraki over a fresh criminal complaint, a Premium Times article, Abuja court summons Jonathan over leadership newspaper's forgery case, a Premium Times article, court orders substituted service of fraud charge on Uwaje, a Sahara Reporters article, speakership, court orders substituted service on Bajabiamila over US fraud, a newspaper article from the Cable, High Court reverses summons on Bajabiamila, a Vanguard article, alleged $200 million check, court orders public summons against Senator Uzodimma, uslegal.com website, and Oxford Dictionary of Laws 5th edition. We also consulted a swab.co.uk resource for the case Goodman vs. Iban J Limited. This video is part of a series of other videos that discusses searches, summons, arrests, and the rights and safeguards for an accused person. Videos that have already been published include the power of search or the power to search under Nigerian criminal law, the power of summons or the power to summon under Nigerian criminal law, criminal summons under Nigerian criminal law, everything you need to know in one video. Videos yet to be published are the power of arrest or the power to arrest under Nigerian criminal law, and rights or safeguards for an accused person under Nigerian law. Note we did not say under Nigerian criminal law, because there are laws that are not criminal laws that also include rights and safeguards for an accused person, such as the Nigerian Constitution. Please take the time to watch the already published videos and come back to watch the videos yet to be published in the future. Those videos will be published within the next 2 weeks. Thank you. This brings us to the end of our consideration of public summons. Thank you for your time and attention.